Every voice matters, and every story deserves to be heard. This is Behind the Wall Voices for Justice, where we bring you real conversations about injustice, resilience, and the fight for freedom. Join me in my discussion today with a paralegal as we break down the walls of ignorance. So, hi, my name's Akira. I'm sure you already know me. We've talked on the phone and
Yeah,
text. Can you
yep,
tell me your name?
yep, yep. I am Eric, last name Hicks. And
So what do you do? What did you do in the past or what do you do currently?
well, right now, I'm an independent paralegal right now.
Mm-hmm.
Um, in the past, I left the streets at a young age. So at most in the past, I was just a student, just getting out of high school when I came
Mm-hmm.
in. So, yeah, yeah, now I'm a paralegal. I got my certification uh from Georgetown University Law School, and that was in 20 let me see, 22. Want to say that was in 23. Yeah,
Okay.
in 23. Yeah, Georgetown University School of Law. So and ever since then, I've been doing law way before that, but I just, I made it formal by graduating
Mm-hmm.
from Georgetown.
And for those of for the people who don't know, can you tell what a paralegal does?
Uh, well, paralegals have a lot of different functions, right? You can you have some paralegals who they tend to do more like ministerial duties around like a law office. I'm not that kind of paralegal.
Mm-hmm.
I'm one of the paralegals who would really work closely with lawyers in crafting arguments, especially with respect to what I do is more like post-conviction to prepare arguments, to prepare motions, to prepare briefs, things of that nature.
So we're gonna hit a few points. I wanted to talk about fraud,
Okay.
specifically fraud in the factum. Um,
Hmm.
Knowledge of this of the substance and the substance being controlled substance in my father's case, and relevant and
Hmm.
acquittal conduct and sentencing and points and guidelines. I definitely think
Hmm.
these last 2 points are
Hmm.
really crucial and really important. Um,
Hmm.
and my father
Right.
thinks, and which is, once we flesh it out and help other people
Hmm.
understand my father's point, knowledge of
Hmm.
substance, I think that'll definitely be a
Right.
good point as well to talk about and help
Right.
people understand. And then I
Right.
guess
Okay.
knowledge of substance carries into the fact that the government and the system committed fraud and has been doing so for decades. Um,
Whew. Truer words had never been spoken.
thank you. Uh, let's get to it. How familiar are you with fraud in the factum and defective indictments?
Um, well, fraud, right? Let me just say, fraud, it is especially when you're dealing with criminal law, it's like a nebulous term, and I say that just because they don't necessarily consider it like if you're raising an issue, right? They wouldn't necessarily call it fraud. I'm like fraud is it's more so used in the civil context. Now you do have like fraud offenses on fraud federal offenses, but as far as like individuals committing fraud, as far as how an indictment was drafted, they wouldn't use it in that context. They would just say more so that the indictment is defective and it either violates a provision of the Constitution or it violates a provision of the rules of federal rules of criminal procedure.
Mm-hmm. So my next question was going to be how often do these courts take these arguments seriously? So I guess because of how they word things, they
Hmm.
throw it under the bus or they don't think as much. They were like, you're not they I guess they would say you're not a lawyer, you don't know what you're talking about. So you're just
Right.
us, the citizens are just spewing out words and so they don't
Hmm.
take us seriously in that sense.
I think that when you when you look at these kind of issues, right, you have to look at them from a historical context. And the reason why I say a historical context is because you have to understand the what the court is designed to do, especially in relation to people who look like us.
Mm-hmm.
Um, one of the court's most significant tools in combating what they allege is the crime wave was the conspiracy statute, 21 USC 846. Um, and that, let me backtrack. It wasn't signed into law. I'm speaking of the Sentencing Reform Act, but the Sentencing Reform Act, it kind of altered the way that 21 USC 846 would be used. And after A7, which is when the Sentencing Reform Act became law, now mind you, 21 USC 846, that had been on the books for a while. That was a statute long before the Sentencing Reform Act. But what changed was how lenient the courts would be in allowing the government wide latitude in how they drafted these indictments to go after the quote unquote scoundrels of that time, which happened to be people in our community.
Mm-hmm.
Uh, 21 USC 846, which is what your father was charged with, right? It is uh that's one of the government's most significant tools. And the leeway that is given to the government, it is whew, I can't even like give you the it's beyond infuriating.
Yeah.
Only because I have seen, personally, I've seen the Supreme Court, they have stretched the Constitution to its limits to to justify what what any individual who has even a rudimentary understanding of law would know it is blatantly unconstitutional. To circle back to your father, his specific case, um, it's a nuanced discussion. And I say it's a nuanced discussion because you can't just you can't just address it from how his indictment was worded. That's one aspect of it. But I say it's a nuanced discussion because it didn't just happen to him, and that's very important. The reason
Mm-hmm.
why it's important is because there was a case that the Supreme Court decided. It was some young guys out of Baltimore. The case was called United States versus Cotton, and it dealt with how these indictments have been drafted throughout the 90s. Um, Naturally, a lot of people inside they were, depending on the Supreme Court to do the right thing in this case. The case basically was it brought to light the lawyers who represented Cotton that in a lot of these drug prosecutions from the 80s and 90s, the government they were tantamount to charging things that weren't an offense. For example, 846 by itself, it's not an offense. It has to. A part of 841, which is the substantive statute, it has to attach to it.
Mm-hmm.
Well, what happened, to make a long story short, the lawyers argued that in that case, because the government only charged a violation of 846, and that's technically not an offense, that the federal courts didn't have power to hear the cases or sentence the defendants.
Mm-hmm.
The Supreme Court, in all of its wisdom, said, well, you have a point. But, and this is a big but, jurisdiction that you're talking about today and that you cite from one of our prior precedents from the 40s, that's not the jurisdiction that we're talking about today.
Mm-hmm.
But jurisdiction it only has one meaning. How does it
Mm-hmm.
not mean in 1940 what it means today? The
Right.
Constitution didn't change, the statutes didn't change. So what they said was, no, we weren't talking about back then a court's the power of a court to adjudicate a case. This is what you're talking about now is the power of these federal courts to even adjudicate these 21 USC 846 cases. We find that they do have power
Mm.
to adjudicate these cases, even if the indictment technically doesn't even allege an offense.
Mm.
So they gave the courts the authority, and then even in an even more sinister move, they said, "Oh, and by the way, um, we will acknowledge that there is some form of defectiveness in the indictment, but what we'll do is we'll allow courts to address it under what's known as the harmless error standard." So what that means is that you have incarcerated me for technically a life. You're giving me life for
Mm-hmm.
something that wasn't even an offense. And you said that my indictment, the statutory quantity for crack, for example, at the time was 50 grams or more. So what they said was, if the court can look at your record from the trial and find that the offense that you actually got sentenced for involved more than 50 grams, then the error was harmless and you basically remain locked up. So
Mm,
and so you really so what you're saying is that basically even though the indictment didn't allege an offense, you are allowing the court to look in the record as if an offense was charged. And if the offense and they're looking, you're looking at testimony from individuals who have cooperated and they say, oh, well, this person gave me X amount of ounces of crack per week. Of course it goes, it exceeds 50 grams. So
mm-hmm.
now I have to sit in jail even though I wasn't charged with an offense, because it was more economical for you to find a way to uphold this conviction because of the number of individuals who you used to deprive of their life or liberty without due process of law.
Mm-hmm.
So now, how does that relate to your father? It comes all the way full circle now. The way that they have worded his indictment and the way that the jury instructions describe the offense to the jury, it's like a standard practice,
Mm-hmm.
even though it's wrong. And so, this is the machine that we're up against, and that's why I say it's a nuanced discussion.
Mm-hmm. Okay, okay. So does that also like how you explained it, does that relate into relative and acquittal conduct of how they or how they look back at what you have done to tack on points, or is that's something different?
Uh, it 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 all correlates. Don't get me wrong. It all correlates, right? Um, I've read cases, like especially throughout the 2000s, ad nauseum about, acquitted conduct, about relevant conduct. Relevant conduct um, is sinister. And the reason why I say it's sinister is this because, and there's a reason why, let me just say, there's a reason why in federal courts, A, they won't allow cameras in federal courts. There's a reason why.
Mm,
And then B, they're the reason why they don't allow the public to have access to what's known as the pre-sentence investigation reports. There's a reason why. Because
mm-hmm.
I think that the public and I don't have a lot of faith in the public. Let me just say that. Sensitized to a degree, but that's a story for another day.
Yeah.
But I think that people of good conscience, people who have moral integrity, it's hard for you to look at what goes on in a federal courtroom or or the things that courts rely on in a pre-sentence investigation report. It's hard for you to look at these things and not walk away in disgust at what occurs in federal court every single day. Um, Acquitted conduct is just what it is. It's acquitted conduct. So what I'll do is I'll walk you through acquitted conduct uh, as it relates to relevant conduct. Um, and I can give you real life examples. Um, there were some guys, right? Just to give you an idea of what acquitted conduct is. There were these guys out of Boston. They went to trial in federal court for murder. Um, uh, the carrying of a pistol after being a convicted felon, and then there was also allegations of murder. Well, they beat the murder charge. They got acquitted. However, remember, when you're in federal court, unfortunately, you're dealing with two different standards of proof. The first is the one that we all know, beyond a reasonable doubt. That's the one that applies to your jury, the alleged group of your peers.
Mm-hmm.
The second standard of proof is the lowest, which is a civil standard, which is called preponderance of the evidence.
Okay.
So even though in federal court you can be acquitted of a substantive offense, if you're convicted of other offenses in conjunction with being acquitted for that substantive offense, then when you get to sentencing, the government gets to basically retry you for whatever you were acquitted for. But this time, the standard of proof is not beyond a reasonable doubt. The standard of proof is preponderance of the evidence.
Preponderance of
So,
the evidence.
yes, and that's used in civil cases. It's basically more likely than that.
Hmm.
So what happened to these guys was they were acquitted of the murder, but they were found guilty of the firearms.
Mm-hmm.
When they got to sentencing, the government was allowed to get a second bite at the apple as to whether or
Mm.
not they committed the murder.
That's
This
crazy.
time, they were able to argue that, hey, even though we weren't able to prove beyond a reasonable doubt that they committed this murder, it's more likely than not that they committed this murder. Now, this is why this is significant. This is significant because now, once the judge makes a finding that it is more likely than not that you committed this murder, the guidelines, they have what's called guideline ranges. So now, if you're just convicted of a firearm, for example, right, you don't really, and you don't have a record, your base offense level will probably be something like a 20 or 22. So you probably be facing, let's say, anywhere from, well, now, because the judge found that it's more likely than not that they committed this murder, their guideline range jumped from a 24 all the way up to a 43. Now, when you get to a 43, that's life. So now the question becomes, well, suppose my statute of conviction, suppose it doesn't carry life. Well, this is what the judge can do. Because they got found guilty of multiple firearm offenses, and all of those and all of the maximum for those offenses was 10 years. What the guidelines told the judge to do is this: if this individual got found guilty of four different firearm offenses and each of those crimes carry up to 10 years, then normally this person would have been sentenced concurrently, which means everything is it just runs into one. So if he gets 18 to 36 months for each count, it's just technically 18 to 36 months because it's concurrent. But because the judge made this finding that they committed the murder, even though they were acquitted, now the guidelines say, oh, what you can do is you can sentence them to the absolute max under each statute. So that's 120 months, 120 months, 120 months, 120 months. And you don't run them concurrently, but you run them consecutively. So now
Wow.
this person just went from a potential sentence of 18 to 36 months up to 480 months. And there were other individuals who got found guilty of like seven gun offenses. So now that person walks away with what was that 800 and I want to say it's like 840 months.
Wow.
So that one finding took this person from 18 to 36 months all the way up to 840 months.
That's a great example. That's crazy because I've heard of the word. I've heard them use consecutively, but I've never heard you said congruently,
Concurrent.
concurrently. So
Yes.
I've always heard consecutively. Like I know back to back.
Right.
So like all together, concurrently.
Right.
That's
Yep.
just
Concurrent.
interesting how like how I like I'm just stunned. Like I've never knew that word in
Mhm.
law. I thought it was always consecutively. Like, oh, okay, just always added up.
Right. Well, no, most cases actually, in most instances, I would say 8 out of every 10 sentences imposed to run concurrently.
Mm,
But the judges do have discretion to impose consecutive, but they very rarely do it,
mm-hmm.
you know.
Okay,
So
okay. So that means like even if the court in federal, you said federal government, federal
in federal district court.
in federal district court. So even if the jury finds them not guilty, why
Mhm.
can the judge then basically charge them again Because it's like, you know how they say, like, oh, you can't be charged again. Like, you're out of prison, you
Mhm.
can't come back and be charged again for the same crime. But they're basically doing that.
I like that question. And the reason why they can do that is this, because in the 90s, and let me just say the 90s was a horrible time for criminal law. Horrible. Because you had all the hysteria about this crime wave. And so in the 90s, the Supreme Court, they came back with a decision that said if you sentence a person based on something that they were acquitted for, it doesn't violate the double jeopardy clause of the Fifth Amendment. So that's how they can do
Oh my
that.
gosh.
Because what you're describing is called double jeopardy.
Mm-hmm.
So the Supreme Court said that it doesn't violate the double jeopardy clause of the Fifth Amendment if I'm acquitted for an offense, but the government chooses and the judge, the government opts to have me sentenced for that acquitted conduct, and the judge actually sentences me for that acquitted conduct, then it's not. Uh, then it doesn't violate the double jeopardy clause. But let
That's
me just say
crazy.
this:
Uh-huh.
the commission, to their credit, they have recently amended the guidelines to try to limit the use of acquitted conduct.
Mm-hmm.
Now, I'll give them credit for that, but uh, I can't give them full credit for it simply because you still have people that's sitting in jail rotten because
Mm-hmm.
they have been sentenced for acquitted conduct, and you didn't make it retroactive. So it doesn't help the person that's already sitting in jail with a life sentence based on acquitted conduct or that has fucking excuse my language, 100 years, 50 years, because you didn't make it retroactive.
Mm-hmm. And so
And you didn't
retroactive
outright bar,
means, huh?
and they didn't outright bar the use of acquitted conduct. They just severely limited it.
Mm-hmm.
Retroactive means that it doesn't apply to anyone whose cases preceded their change to the guidelines.
Okay, okay. That's crazy. Okay,
Yeah,
so I see where my dad was like, he made a script for me or was like, hey, do this. And
right,
he has so many thoughts and I'm trying to get it out there for him. And
right.
now when I'm reading it, I'm just like, I don't even know what these words are. Then I gotta go to work. I gotta do this. So
Yeah,
it's good to know, and I'm really glad to have this interview conversation.
yeah,
Um, so we
yeah.
touched on
And I'm going to talk
fraud.
more about his,
Yeah.
more about. Go ahead, I'm listening.
Oh, no, I was gonna go to the next things or try to transition. Go ahead.
Okay. Well, yeah, what I was going to say is, given a chance to, I'm going to circle back to his indictment because there's some things that I want to explain to the viewer so that they
Mm-hmm.
can understand what actually happened with respect to what he was charged with and why it matters.
Mm-hmm. But fraud. So we touched on fraud a little bit
Hmm.
and
Hmm.
our thought process of it. Then fraud in the factum says, what is fraud in the factum? I remember I just can't.
Remember, what I was saying about fraud is like now what you can what how you would frame it is this. What happened, like the way that the count was drawn, it can be deemed as fraudulent, but the terminology we use to describe what happened is that it violated the Fifth and Sixth Amendment because you have
Okay.
right, to notice, and you also have a right for a jury to find that you are guilty of every element of the offense beyond a reasonable doubt. So the way that his indictment was drawn, it pretty much relieved the jury, or it relieved the government of proving that he was guilty of every element of the offense beyond a
Mm.
reasonable doubt.
Okay. So then say like I think how his indictment he was charged with having controlled substance, but they didn't prove
Right,
he knew. But I think he said there was two other counts he was acquitted of or wasn't charged of, or the jury found
right.
him not guilty of. So
Hmm.
they charged him with having the controlled substance, but
Right,
and I think he said he would have gotten like just 17 or so years for that, but because of a gun charge,
right.
things he was acquitted of, and
Hmm.
they tacked that on. So again, that's why I want to focus on the point system but he really wants to focus on the wordage.
Right.
Um, so that's
Well,
how
we have
that.
enough time to touch on both.
Huh? Okay.
Hmm.
But that's how that
Yeah.
happened for him basically. And he wants to
Hmm.
say they're committing fraud, but you're saying that how they worded it, the indictment, they got around it, but he's trying to say um that the wordage, he's trying to say that the wordage isn't in layman's term for the jury to understand, and that's
Hmm.
fraudulent and they didn't do that right. But
Hmm.
either way, what he's trying to say that you read his indictment and the way they
Hmm.
worded it, they got around it.
Well, they didn't get around it because we see it now. You
Okay.
know, the problem is
They threw a curtain over
because
it a little bit.
right, and the problem is that because he raised this issue in his 2255, which
Hmm.
is
Hmm.
it's like the federal version of like a habeas corpus, but and it didn't get the reception that it merited because of that nuanced discussion that we were having earlier about the courts. Just because you've been doing a practice for so long, you assume that it's correct, and we've seen this before. It happened in 2000 when the Supreme Court came back with a case, and ironically, it was a case involving a hate crime, but it wound up having a greater impact on people that look like us, in that because what they said in that case was that any fact that increases your punishment beyond the statutory maximum, it's basically an element of the crime which must be proven to a jury beyond a reasonable doubt. It has to be charged in the indictment and then submitted to the jury and proven beyond a reasonable doubt. Why that's important is because throughout the 90s, they allowed us to be sentenced or charged and sentenced under a statute that really set forth three separate crimes. But the way that they understood the statute was that it was just one crime. So you
Mm.
would come in and you would be facing anything from 0 up to life. And they wind up correcting that. But again, the carnage was already done. So he correctly submitted his claim to the judge, but because the judge is so familiar with the government charging conspiracies, the way that they charged it in his indictment, it's something that the judge just wouldn't touch.
Okay, okay. That's good to know.
Hmm.
Knowledge. So a third point was, or second point was knowledge of the substance. Um,
Hmm.
should we just go to relevant and acquittal conduct? Like, because is knowledge of the substance circling back to his indictment?
Uh, yeah, and I'll just say this.
Mm,
You have to have knowledge of that what the personnel, the government may not have to prove the exact type of controlled substance, but you have to have knowledge that what's being trafficked is a controlled substance.
mm-hmm,
And the way that his indictment was worded, it relieved the government of its burden of proving that what it is that was being trafficked, that he knew that it was a controlled substance.
mm-hmm. How?
So according to the Fifth and Sixth Amendment, he can't be guilty because that that the way that it's worded, technically it doesn't state a crime.
Mm-hmm,
It doesn't.
mm-hmm. And it's so funny. We have a family member. I forgot what she does, but we have a family member like,
Mhm.
hey, can you help us? I thought she was an English major, but she's like, hey, can you help us
Mhm.
draft a letter
Mhm.
for knowledge and just the wordage of this? And she was like, no, oh geez, I kind of lost my point, but she was like, no, no, you
Mhm.
need a lawyer. You need to go get a pro bono. He has a key. They can help him, but I'm um just go ahead and draft up a letter and because you
Mhm.
need specific legal terminology in your letter to
Mhm.
help him. But I'm like, because I didn't get it, so of course she won't get it
Mhm.
I think we
Mhm.
just spoke to her for 3 days, so she won't get it in 3 days. But she didn't
Mhm.
understand that we were trying to say this the word the knowledge and and how they found the knowledge that they didn't prove he knowingly knew it was a controlled substance properly. And we're trying to explain that to people, and that, again, legal jargon needs to be in layman's term for citizens to understand, right? So that's why we wanted the expert English teacher to be able to write their opinion and their piece on that phrase, knowledge, knowingly, and controlled substance. And but she didn't get it, so I was like, I'll just let her talk.
And listen, it's very frustrating. It's very frustrating. And to mention, to delve into acquitted conduct, it's sad that counts, or that conduct was still used to influence his overall sentence. Now, what's even more tragic is this: if he were sentenced today, chances are they wouldn't be able to use it. But because it wasn't made retroactive, he can't use it. That's sad.
Yeah.
It's sad because even people who don't really know about the law, everybody knows what it means to be found guilty beyond a reasonable doubt.
That's mostly
Everybody
what
knows.
all people know. They just know that, and like, oh, everything
Right,
should be fair. That. But there's so
right,
many other things we
right.
don't know.
And then what happens when you find out that it's not fair? You see what I'm saying?
Mm-hmm.
What does that do to your faith in the system? What does that do to your faith in the country that you would allow people to languish in jail for something that a jury of their peers said that they didn't do?
Mm-hmm.
Like,
And
how barbaric is that?
yeah, and I think most of us as a community, we do know that we can't really have faith
Yeah.
in the system, but then there's so many of us out there. Like before I think my dad's been trying to do this since he's been in. But I think we've been doing this for 2 or 3 years. Had the Manumit Me business.
Mhm.
Oh, I forgot my point again. But it's crazy. Like before that, I was just going about my day, and I knew the system was crazy, and the government was terrible. But I was like, what can I do? So I'm glad I'm
Right.
doing this, and it's slow moving, but I'll try to get there.
Listen,
Like I'm about to say, I'm no activist, but it starts somewhere. It starts somewhere.
The walls we build couldn't silence the truth. Behind every statistic is a person and a story that demands listening. We explore justice with depth, stories, experts, and the communities living them. Join us, subscribe, and share to amplify voices for justice.